Hello everyone, this is day 17 of Polity Daily Drill. Let's begin. First question. Consider the following statements in context with the Representation of the People's Act 1951. The Act lays down the actual conduct of elections in India, including the administrative machinery for conducting elections, the poll process, and the counting of votes. Now, statement 1 is absolutely correct. In fact, RPA 51 is the major law dealing with matters concerning elections. Coming to statement number 2, Section 8 of the Act, specifies the duration of disqualification from contesting elections for persons removed from government office due to disloyalty. Now, certain sections of RPA 51 are extremely important. Section 8, 8A, 9, 9A, 10, 10A. These sections are meant for disqualification for candidates, and of course section 11, which gives Election Commission the power to either remove or reduce the period of disqualification for people who want to contest elections. Now, the statement talks about how Section 8 relates to the government employees who are disqualified because they were dismissed for disloyalty. Now, this is wrong. Why? Because this is not Section 8 but Section 9 of RPA 51, right? Section 8 deals with those people who are disqualified on the grounds of criminal offences. It has three subsections, 8(1), 2 and 3, which deal with different kinds of laws. Extremely important. Please revise these sections. So 2 is wrong. The question says which of the above statement is incorrect, right? So B, 2 only is the answer. Don't mark 1 by mistake. Coming to the second question, the Indian Constitution has provisions for the establishment of tribunals in the country. In this context, which of the following statement regarding the tribunal is not correct? There was no provision regarding the creation of tribunals during the commencement of the Constitution. Now, this is actually true. If you think about it, in 1950, when we had the commencement of the Constitution on the 26th of January, there was no provision to create tribunals. Yes, the word tribunals is mentioned under Article 136, under Article 227. However, there is no explicit provision to create tribunals. So 1 is correct. Second one, the provisions regarding the tribunals were added by the Constitution 42nd Amendment Act. So this is also correct. The provision for tribunals were added by the 42nd Amendment Act of 1976. Coming to C, the state administrative tribunals are established by the state legislature by law. Now this is where the problem lies. Because if you look at Article 323 capital A, it talks about creating tribunals on administrative matters. And only the Parliament has the power by law to create tribunals for the centre or the state government employees. So, CAT and SAT, which have been established under the provisions of 323A through the Administrative Tribunals Act of 1985, are done via the Parliament by law, not the state legislature. C is wrong since we had to find the incorrect statement. C becomes the answer. And let's look at D. Awards of NGT, that is the National Green Tribunal, can be challenged only in the Supreme Court. This is also correct. NGT Act 2010 mentions this very clearly. Moving on to question number 3. Which of the following are discretionary powers of the governors in India? Number 1, Special responsibility with respect to law and order in the state of Nagaland. This is actually correct. If you refer to Article 371 capital A, this is true. Number 2, special responsibility for peace and ensuring the social and economic advancement of different sections of the population of Sikkim. This is also correct. Again, if you refer to Article 371F, section or rather clause G, this is correct. Coming to number 3, declaring that no act of parliament shall apply in respect of religious or social practices of the Mizos in Mizoram. Now herein lies the problem. This statement is correct, but it is not the discretionary power of governor. Why? Because Article 371G, which is meant for Mizoram, says that in a sense that regardless of what is stated elsewhere in the constitution, the implementation of any parliamentary act relating to the Mizo religious or social customs, their customary laws and procedures, matters of civil and criminal justice involving these customary laws, as well as land ownership and transfer. Now, these will not be effective in the state without the explicit approval of the State Legislative Assembly of Mizoram, right? So, the SLA through a formal resolution has to approve, and only then will those laws apply. It is not the discretionary power of the governor. So, 3 is not correct. Hence, the right answer is A, 1 and 2 only. Moving on to question number 4. Consider the following statements regarding Article 22 of the Indian Constitution. Under Article 22, an individual detained under preventive detention has the right to be produced before a magistrate within 24 hours of detention. Now, this is actually not correct. See, the second part, that is within 24 hours you need to be presented before a magistrate, is correct, but only for those who have been arrested under a punitive detention, not preventive detention. So, 1 is incorrect. Number 2, the provisions of Article 22 apply uniformly to both Indian citizens and foreigners. This is also wrong. Why? Because we know that the 3 benefits, meaning number 1, providing reasons for arrest, number 2, providing with some kind of legal assistance, and number 3, presenting before the magistrate within 24 hours. These 3 benefits may not be given to those who are arrested under preventive detention laws, as well as those who are enemy aliens, right? So, 2 is also wrong. Coming to number 3, laws on preventive detention can be made only by the parliament. This is also incorrect. Why? Because preventive detention as a topic is under Union List entry number 9, as well as concurrent list entry number 3, which means that the states also have the authority, the power to make laws on preventive detention. All 3 statements are incorrect, and we have to find out how many statements are not correct. C is the answer. All 3 are not correct. And the last question for today. Assertion: no member is liable to any court proceedings for any vote given within the precincts, that is the boundary of the house, even if the member has accepted a bribe to cast his or her vote. And the reason is, the purpose of parliamentary privileges is to ensure that members perform their duties without fear or favor, affection or ill will. Now see, parliamentary privileges are mentioned under Article 194 for our MLAs, Article 105 for our MPs. Now, reason is actually correct. But what about assertion? This would have been correct till February 2024. Why? Because recently there was a judgment, Sita Soren case 2024. Now, in March 2024, a 7-judge bench of the Supreme Court unanimously held that members of parliament, that is the MPs as well as the MLAs, MLCs, all these legislators are not protected with immunity under Articles 105 Clause 2 or 194 Clause 2 in cases of bribery. So, in case you take money to cast your vote, sadly, you will not be given the protection that you otherwise have with respect to any vote given in the House. So, assertion is wrong, but reason is a correct fact. Hence, D. A is incorrect, R is correct is the right answer. This brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that is all for me, guys. Jai Hind.